Dear all, online and in person, welcome to the Asser Institute and to this DILEMA-HILAC lecture. So my name is Christoph Paulus and I'm the acting academic director here of the Asser Institute. And as mentioned, the lecture of this afternoon is organized by DILEMA and HILAC, which are two acronyms that I will now explain to you. So DILEMA stands for Designing International Law and Ethics into Military Artificial Intelligence. And this Asser project explores interdisciplinary perspectives on military applications of AI with a focus on legal, ethical, and technical approaches on safeguarding human agency over military AI. And it analyzes in particular subtle ways in which AI can affect or reduce human agency and seeks to ensure compliance with international law and accountability by design. And HILAC stands for the Hague Initiative for Law and Armed Conflict. And within this initiative, lectures have been organized here by the Asser Institute in cooperation with the Amsterdam Center for International Law and the Netherlands Red Cross since 2005, so almost 20 years now. I would like to take this opportunity to thank my colleagues Taylor Woodcock, Eva da Costa and Valeria Lopez for the organization of this event, and for Dustin Lewis, who will be introduced by Taylor in more detail after my introductory remarks, for his willingness to share his insights on both natural and artificial intelligence in armed conflict. And yeah, great to see you again here, Dustin. So thanks to all of you. Enjoy the lecture. Please be interactive and ask many questions. And Taylor, you have the floor.
Welcome everybody, my name's Taylor Woodcock and it's my pleasure today to moderate this joint DILEMA-HILAC lecture given today by Dustin Lewis. And Dustin will be speaking to us about the broad range of potential applications of artificial intelligence in the military domain, exploring the relationship between natural and artificial intelligence in armed conflict and consequences for the regulation in this domain, judgment in legal obligations and possibilities for accountability, which of course is a very timely discussion. We are thrilled to have a leading thinker in the field with us today as our special guest lecturer, Dustin Lewis. Now, Dustin is the research director for the Harvard Law School program on international law and armed conflict. With a focus on public international law sources and methods, he leads research into several wide-ranging contemporary challenges relating to securing peace, safeguarding the environment, and ending armed conflicts. Now, in addition to managing the program's research, publications, and online platforms, Dustin regularly briefs governments, United Nations system actors, scholars, members of the media, and NGOs. And in addition to all of this, Dustin is also currently an associate senior researcher in the governance of artificial intelligence at the Stockholm International Peace Research Institute, SIPRI. Dustin's now going to deliver his lecture, after which there will be a Q&A with the audience. For those here in person, you'll be able to raise your hand, and for those online, we ask that you kindly put your questions into the Q&A in the chat function. Without further ado, Dustin, thank you so much for joining us today, and I invite you to take the floor.
Good afternoon. I would like to begin by thanking Dr. Marta Bo, Dr. Berenice Boutin, Taylor Woodcock, and Claudia Klonowska for helping arrange this talk today. I was last at the Asser Institute in the audience for an event when I was a visiting professional in chambers at the ICC, having just graduated from my LLM at Utrecht. So it's an honor and a privilege to be back at this world-class institution from this vantage point. This afternoon, I will share some ideas based on research that I've been conducting with colleagues at the Harvard Law School program on international law and armed conflict. And I'd be grateful for any critical feedback that you may have as we puzzle through some complex issues that draw on multiple fields of academic inquiry, policy, and practice. To summarize at the outset, my argument is that it is useful at the current stage of the multilateral debate on the use of artificial intelligence in armed conflict to formulate properties of legality and corresponding conditions of legality that states and other parties might be persuaded to commit to instantiating. These properties and conditions may help frame and encourage substantive conversation, including among states and other stakeholders with widely differing views on the relative desirability or inappropriateness of using AI in armed conflict, on what the law already requires and what it ought to require. One way to formulate these properties and conditions is by drawing linkages concerning exercises of natural intelligence and artificial intelligence alongside assumptions underlying how legal obligations may and must be performed and criteria for legality. So after attempting to generate some elements of such an analytical framework, I'll propose a handful of properties and conditions of legality for consideration. Some relate to AI in particular, and others are of a more general character. The two AI-related aspects concern, on the one hand, ascription of the acts necessary to perform obligations only to natural persons. And on the other hand, the apparent requirement in performing these obligations for natural persons to undertake and carry out what I call an exercise of cognitive agency. That requirement cannot be satisfied, from my perspective, solely by reliance on algorithmic and data-shaped information or recommendations. The more general sets of properties and conditions of legality, which entail implications for uses of AI, concerned whether armed conflict-related conduct must be ascertainable, and whether it must be possible to apply responsibility in case of breaches. I am taking this approach in part because, from my perspective, concerns around the use of AI in war invite us to reflect by going back to the basics. To be certain, I am not seeking to make a future-oriented prescriptive claim. Rather, I'm trying to understand the legal framework as it exists under its conventional approach. While much of the literature and policy debate in this area focuses on individual criminal responsibility, especially war crimes, I will be primarily discussing state responsibility, both in terms of what it means for the obligations incumbent on states to be performed, and in the sense of applying responsibility in case of breaches. If there are innovative aspects in my approach here, I suppose they might be found first in my two-step argument that under existing international law, only natural persons are capable of performing obligations on behalf of legal subjects, and that a necessary part of that performance entails an exercise of cognitive agency by the natural persons or natural persons responsible for performing the obligation. The other potential innovation is in setting out the more general characteristics of a legal framework in terms of subjects committing to act only in ways that are ascertainable from a legal perspective and in respect of which responsibility is capable of being applied in case of breaches. I do not approach the legal regulation of AI in war from the starting point of certain notions that have featured extensively in multilateral debates on autonomous weapons, such as a human being on, in, or out of the loop, meaningful human control, or appropriate levels of human judgment. From my perspective, to exercise cognitive agency in a legal sense, the mere presence of a natural person at a certain point in the process would not suffice. Nevertheless, if my claim that the natural person or persons responsible for performing the obligation on behalf of a subject must exercise cognitive agency is well-founded, that claim may help inform and shape understandings of those and other notions from a legal perspective. Further, by spanning out to a satellite view regarding the law itself, I aim to encourage reflection on what it means to speak of a legal system of meaningful protection in relation to war, and what we ought to accordingly require of states and other relevant actors with respect to the development and use of natural and artificial intelligence in armed conflict. Having sketched my argument, I will now build out my reasoning over 5 sections. First, I will say a word on the overarching frame of the talk, explaining my methodology and making some caveats. Second, I will set out some considerations related to expectations concerning intelligence in war. Third, I'll discuss some ways that those expectations might be understood to relate to the legal framework. Fourth, I'll propose a handful of properties and corresponding conditions of legality concerning exercises of cognitive agency in armed conflict. And fifth and finally, I will close by postulating a few implications regarding respect for the existing law and possible development of new law in this area. So I framed this talk in terms of natural and artificial intelligence in armed conflict with a focus on exploring certain legal questions that might be characterized as relatively open or settled. There are a few reasons I've chosen this frame. First, instead of focusing on AI in armed conflict as such, I think that there is descriptive, analytical, normative, and operational value in concentrating on exercises of intelligence in war more widely. Part of the reason to focus on armed conflict, of course, is because of the life and death stakes entailed in so many war-related decisions and judgments. Further, this frame permits an exploration of ways to conceptualize connections and distinctions between exercises of natural intelligence and artificial intelligence, both in war and more broadly. Another part of my reasoning for adopting this frame is that more and more states and commentators are focusing on how to regulate increasingly complex so-called human-machine formations or human-machine teams, many of which have been said to employ techniques and methods drawn from the science of AI. In addition, there is a near continual stream of news reports, policy publications, and military indications that more and more armed forces are developing and using AI-related techniques and methods in relation to armed conflict. While there are many dimensions to these issues, my sense is that it's useful to focus in part on how, when, where, and why intelligence, whether it's natural intelligence, artificial intelligence, or some combination, is exercised and how that relates to legal requirements and prohibitions. So far as I have seen, there have been few attempts to understand these developments and their implications by examining those exercises of intelligence as conceptual units of legal regulation. Second, I have chosen to focus on certain legal aspects concerning exercises of natural and artificial intelligence in armed conflict. A starting point here is that one of the most vexing challenges I know of is how to establish and implement a functional system of legal protection in relation to armed conflict. I made this framing choice in part because, unlike domestic law, corporate codes of conduct, or ethical guidelines, international law is the only framework that all states agree is binding in relation to armed conflict. I think there is value, therefore, in exploring how expectations concerning intelligence, exercise of intelligence in war, are related to the legal framework, both in theory and in practice. Notably, there are no specific rules or regimes governing exercises of natural or artificial intelligence in armed conflict as such. So at least for now, we need to inquire into how the existing rules already do and do not account for those exercises of intelligence. From my perspective, despite recent scientific advancements and uses of new technologies, several key legal issues are arguably settled. At the same time, however, there are a number of legal questions that arguably remain open, and in my view, states and other concerned actors ought to confirm the settled matters while also addressing the unsettled issues as a matter of priority and urgency. Third, again from my perspective, the multilateral policy debate in this area has largely been dominated by concerns regarding autonomous weapons. That said, more recently, a growing number of states are focusing on concerns regarding uses of AI-related techniques and methods in the military domain. I am increasingly concerned that what I see as a normative impasse on autonomous weapons may be replicated with respect to military uses of AI. That normative impasse, in short, is that some states think the existing law suffices, others think new rules must be developed, and certain other states seek to bridge the growing chasm between these poles. A concern here is that if these trajectories continue, the normative framework may bifurcate, resulting in relatively restrictive or permissive norms in a system meant to be universal. From my perspective, one way to seek to promote legal stability and the universality of the legal framework is to formulate properties and conditions of legality to which states might be persuaded to commit. Doing so may help us determine whether existing practices conform to a functioning system of protection in armed conflict. As a final framing matter, I want to say a few words on methodology and make some caveats. Regarding methodology, I've employed what might be called the standard set of traditional sources and methods of public international law as part of an effort to identify the existing rules and the responsibility frameworks in which they're meant to operate. Further, I've acted as a participant observer in debates on autonomous weapons and on the use of AI in the military domain, engaging with armed forces, humanitarians, diplomats, human rights advocates, legal advisors, and technical specialists. I've attended numerous intergovernmental meetings, convened workshops with militaries and humanitarians, and have sought to follow developments in literature closely. With a team of research assistants, I have also sought to learn about the science of AI, robotics, epistemology, and related fields. Yet I am by no means an expert in any of those domains. Similarly, also with a team of research assistants, I've examined some of the philosophical underpinnings of the law and legal systems, though again, as a non-expert. The bulk of the research that I've conducted was in English, whereas our research assistants conducted it in English, French, Spanish, Chinese, and Russian. I do not, and indeed could not, claim to have comprehensively surveyed all relevant state and judicial practice, military doctrine, developments in technology, humanitarian and human rights concerns, and the like. Along similar lines, I make no claim to have exhaustively identified properties and conditions of illegality. As I noted at the outset, I'd be grateful for critical feedback on all aspects of the talk, not least those parts of the talk that draw on fields that I do not specialize in. Having sketched my frame and methodology, I'll now discuss some considerations regarding expectations concerning intelligence in war. My sense is that when we talk about law in this area, we have certain underlying expectations, and I'll try to identify some of those expectations. And later, I'll try to link those expectations to the legal framework. By intelligence, I do not mean intelligence primarily or only in the narrow sense of the collection of information of military value. That is, of course, an important aspect of many military and other security operations in contemporary wars. Rather, for my purposes here, I mean to widen the aperture to address intelligence in a much broader sense. Arguably, this wide approach can help distinguish and draw linkages between natural intelligence and artificial intelligence. As a starting point, it is critical to underline that none of these notions, natural intelligence, artificial intelligence, and intelligence more widely, enjoys anything close to a universally agreed definition, whether from a legal perspective or from other domains of knowledge and practice. Nonetheless, for the purposes of my analysis today, I'll define intelligence as encompassing a notably broad set of capabilities, capacities, and functions, including those related to the development of the faculty to understand something, mentally apprehending something, obtaining information or knowledge concerning something, reasoning effectively with respect to something, and exchanging information or knowledge about something. By natural intelligence, I will mean the exercise of those capabilities, capacities, and functions by natural persons, that is to say, humans, whether individually or in groups. And by artificial intelligence, I will mean the field of inquiry and practice concerned with the development of computationally based understandings of intelligent behavior, typically through two interrelated steps. One step is the determination of cognitive structures and processes and the corresponding design of ways to represent and reason effectively. And the other step relates to the development of theories, data, algorithms, equations, and systems that embody that understanding. How does all this relate to war? There's a nearly endless list of armed conflict-related tasks that involve multifaceted and diverse exercises of cognition, such as conceptualizing and implementing military strategies, concepts of operations, and tactical maneuvers, training armed forces, testing and validating weapons and means of warfare, administering logistics, commanding forces, conducting hostilities and other military operations, providing humanitarian services, depriving people of liberty or otherwise restricting liberty, providing legal advice, administering occupied territory, and evaluating and applying legal responsibility in case of breaches. From my understanding, there's an expectation, in short, that one or more responsible humans acting on behalf of a party to an armed conflict will exercise the various kinds and degrees of intelligence required to undertake and carry out these and other tasks. Increasingly, a number of states are relying on AI-related techniques and methods with respect to certain aspects of those exercises of intelligence. I'll give some examples. With respect to directing attacks, the humans acting on behalf of the party need to, among other actions, develop and maintain sufficient situational awareness, including with respect to ascertaining who or what may and may not be subject to attack. They must determine whether incidental civilian harm is anticipated, and if it is, ascertain whether that harm would be excessive in relation to the concrete and direct military advantage anticipated, and they must take all feasible precautions to avoid, and in any event minimize, such incidental harm. AI-related methods are reportedly being employed in certain contexts as part of the processes to identify, nominate, or select objects of attack. With respect to deprivation of liberty, in certain international armed conflicts, the humans acting on behalf of the party need to, among other actions, determine who qualifies as a prisoner of war and who qualifies as a civilian, evaluate whether imperative reasons of security exist so as to justify interning civilians, and continually monitoring the situation to determine when the reasons for internment no longer exist. such that the civilians must be released. It has been reported that certain armed forces have employed algorithmic and data-reliant methods as part of processes aimed at determining who should be detained in order to prevent attacks. With respect to humanitarian services, the humans acting on behalf of the party need to, among other actions, develop and maintain an understanding of the nature and scope of humanitarian needs, determine the measures necessary to effectively provide humanitarian aid and protection to civilians in need and fighters or to combat, and exercise judgment regarding what it means to do so on an impartial basis. It has been reported that certain humanitarian bodies are experimenting with algorithmic and data-reliant methods as part of processes aimed at forecasting humanitarian needs and more efficiently allocating humanitarian services in certain contexts. And as a final example, with respect to the provision of legal advice, the humans acting on behalf of the party need to, among other actions, develop and maintain a sufficient understanding of the situation, ascertain what rules apply in respect of the situation in general and in respect of a discrete operation in particular, exercise legal judgment, and communicate those rules and that judgment effectively to relevant colleagues. It's been reported that certain armed forces are assessing the possibility to rely on AI-related methods as part of processes aimed at identifying legal rules and evaluating the legality of proposed conduct. All these examples involve various exercises of intelligence that we have long expected to be undertaken and carried out by natural persons. Operating on behalf of a growing set of states, those natural persons are apparently relying to a greater degree, or perhaps to a different degree or nature, on AI-related methods. One way to assess the nature and extent to which such reliance is or should be permissible is to relate those forms of reliance to the legal framework. Therefore, having set out some basic expectations concerning intelligence in war, I will now discuss some ways in which those expectations relate to the legal framework. I will focus on who can and must perform obligations and what is entailed in doing so. To establish this part of my argument, it may be useful to first lay some common ground regarding the anatomy of international legal obligations. I will do so through two prisms. On the one hand, some of the conceptual building blocks of obligations, and on the other hand, some legal criteria to apply responsibility in case of breaches. I will start with a very brief background on the subjects and the nature of obligations. The recognized subjects of obligations include individual states and groups of states, non-state parties to armed conflict, and individual natural persons, which is to again say humans, whether or not they're acting on behalf of another subject. The nature of the obligations may vary. They can include, for example, obligations of result, which require the factual obtainment of a particular situation, and they can also include obligations of conduct, which require implementation of specific means or courses of action, as well as others. So against that backdrop, I'll now look through the first prism in an attempt to outline part of the anatomy of obligations by setting out a few building blocks. Those building blocks relate to required acts and ascribing those acts to natural persons. These building blocks are important in relation to AI and armed conflict, because if accepted, they would entail certain legal parameters regarding who can and must perform an obligation and how they can and must do so, the conditions under which they can do so, and the speed at which they can do so. In turn, those aspects would impose implications regarding the nature and extent to which natural persons may or may not rely on AI-related techniques or methods consistent with international law. One building block concerns who may perform obligations incumbent on legal subjects. This building block rests on the assertion that the existing legal framework presumes that only natural persons, not artificial or synthetic agents, are capable of performing obligations. According to this line of argumentation, the conduct and the consequences flowing from such conduct must be ascribable to one or more natural persons acting on behalf of the subject. The conceptual framework I'm seeking to develop here is predicated in no small part on whether these claims are well-founded. A counterargument is that the operative presumption is either factually incorrect, now in the sense that there's no such assumption, or that if the presumption is correct, it should not necessarily hold, because artificial or synthetic agents ought to be considered capable of performing obligations. Yet from my perspective, this counterargument fails, at least insofar as the evidence of states' views in this area including positions set out by the US Department of Defense and the Swiss government, suggests that the principal subjects of international law today presume that only humans are capable of performing obligations on behalf of subjects. A second building block relates to the constitutive elements involved in the conduct entailed in the performance of the obligation concerned by one or more natural persons. This building block rests on the general assertion that under the existing legal framework, the performance of an obligation by a subject requires the undertaking and carrying out of an act or acts by a natural person acting individually, or multiple natural persons acting in a group. And in turn, and this is key for my argument, in discussing natural and artificial intelligence in armed conflict, as part of the undertaking and carrying out of the required acts, that person or those persons must exercise cognitive agency. In other words, the act or the acts required by the obligation includes, as part of the process of doing or affecting something in the world, an exercise of cognitive agency in the sense of an operation of mind or intelligence by one or more humans. Without such an exercise of cognitive agency, the obligation cannot and will not be performed. What precisely is required in terms of an exercise of cognitive agency depends on the obligation concerned. Now, a counter-argument to this building block is that the law is not framed in terms of requiring an exercise of cognitive agency as such, and that this notion is therefore of an extra-legal character. Yet from my perspective, this counter-argument may be, while it may be partially correct in that the notion does not yet enjoy widespread usage, the counter-argument arguably fails insofar it does not provide an alternative understanding of what the law does require in terms of exercising intelligence as part of the process to perform obligations. This notion of exercising cognitive agency as a constitutive element of the performance of an obligation incumbent on a subject should be distinguished from the mental state necessary to establish and apply individual criminal responsibility for an international crime. In other words, an exercise of cognitive agency in this sense is not coterminous with mens rea. While the two may be related in the sense that they both involve an operation of mind by one or more natural persons, an exercise of cognitive agency is a requirement to perform an obligation, whereas mens rea is the mental state that must be established to apply criminal responsibility, in terms, for example, of a certain kind or degree of knowledge, intent, or both. Now, I realize that this notion of exercising cognitive agency that I'm proposing is not a term of art, nor is it recognized as a constitutive element of the performance of an obligation by a subject, nor does it define what precisely is required in each such exercise, for example, in terms of knowledge, intent, volition, and other similar notions. Further, I recognize that the English term agency, when used in this sense, has no precise cognate in many other languages, such as French or Spanish. Be that as it may, I'm seeking, through observation and deduction, to ascertain assumptions underlying the standard account as to how states and other subjects perform obligations that are incumbent on them. And I assert that the law as it exists appears to presume that a natural person acting individually or multiple natural persons acting in a group will, as part of the act or acts required by the obligation, exercise this cognitive agency. And my sense is that while this is a new theoretical approach, or perhaps more accurately, a specification of an existing approach to obligations, legality, and responsibility, it might reflect a standard account of the presumptions underlying the performance of obligations incumbent on legal subjects. That said, I'm especially keen for critical feedback regarding the extent to which this framing comports with such areas as philosophy and legal theory, neither of which I specialize in. Yet my hope, in short, is that this notion of exercising cognitive agency can help to accurately describe the legal framework as it exists, to specify what particular obligations entail in terms of humans exercising intelligence, and to frame discussion on what is required of humans with respect to the use of AI-related techniques and methods in armed conflict. To be certain, this approach does not preclude reliance on AI-related technologies as such. Rather, it frames a key question in terms of the nature and extent of such reliance by natural persons, in terms of how those people effectively exercise cognitive agency. Depending on further analysis, it might be argued that in respect of a particular context, natural persons ought to rely, or might purportedly even be said to be obliged to rely, on certain AI-related methods, while reliance on the same or other AI-related methods in respect of other contexts, may be prohibited or subject to further restrictions or requirements. Having examined the anatomy of obligations through the prism of certain building blocks of those obligations, I'll now seek to distill some criteria as to what counts as law and what makes for a functioning legal system through the prism of responsibility for wrongful acts and international crimes. In doing so, I'll attempt to identify some constitutive elements of the law and some of the necessary elements of a legal framework more widely. The idea is that any conduct that does not satisfy these criteria would not be capable of comporting with the law. In other words, in a sense, by determining what is required to ascertain and apply responsibility in case of violations, I'm seeking to reverse engineer what the law requires. An assumption underlying this part of my argument is that to function in a legal system, subjects must commit to making their conduct susceptible to an assessment of legality and to imposition of responsibility in case of breaches. These are especially hard challenges, I submit, with respect to armed conflict, not least the so-called double black box in which algorithmic opacity is encased in military secrecy, being used as a justification for non-disclosure in numerous contexts. By way of brief background, with respect to international law applicable in armed conflict, there are two institutions of responsibility: the international responsibility of a state or an international organization for an internationally wrongful act, on the one hand, and individual criminal responsibility for an international crime, on the other hand. Regarding state or international organization responsibility, it is well established in public international law that to apply responsibility for a breach of an obligation, 4 elements must be present. There must be conduct that is attributable to a subject. The subject's conduct must constitute a non-performance of an obligation incumbent on it. No circumstance precludes wrongfulness. No circumstance precluding wrongfulness operates in respect of that non-performance, and consequences are imposed on the violative subject. And as for individual criminal responsibility, it's well established that to apply responsibility for an international crime, 5 elements must be present. There must be conduct attributable to a subject. That conduct must constitute a prescribed act or omission. The subject must have had the requisite mental state. The subject must have carried out the prescribed conduct through a recognized mode of liability, and no excuse or justification may operate to vitiate criminal responsibility. Now, I contend that one element of law that we may derive from the theoretical underpinnings of these frameworks is that it must be feasible for a relevant actor to ascertain the legality or illegality, as the case may be, of the relevant conduct, including conduct involving AI. Further, I assert that one necessary, though not sufficient, criterion of a functioning legal system is the possibility to apply responsibility in case of violations. Some counterarguments to these assertions might include that the legal system requires only that conduct comports with legal requirements, not also that the conduct can be ascertainable during or after the fact, as well as the contention that subjects of law are not required to ensure their conduct is practically susceptible to juridical scrutiny. From my perspective, these counterarguments fail to offer a sufficient alternative articulation of what elements underlie a functioning legal system, failed to take into account existing requirements for investigating alleged breaches, and failed to indicate why the proposed elements are supposedly not necessary for us to speak of an effective legal system of protection in relation to war. If my 2 claims are well-founded, they would arguably matter with respect to the use of AI in armed conflict in various respects. That is because reliance by natural persons on certain AI techniques or methods may pose challenges to satisfying these criteria. Indeed, some of the hurdles might already be insuperable with respect to some AI. In other words, the use of certain AI techniques and methods in armed conflict may already be legally impermissible on one or other of these bases. Further, to satisfy these criteria of legality, other existing and potential uses of AI would arguably need to be undertaken and carried out by natural persons in a manner that conforms to the parameters entailed by these elements, which may pose further practical limits and requirements concerning employments of AI in armed conflict. For instance, if adopted, these claims would preclude uses of AI in war that cannot be subject to legal scrutiny and to imposition of responsibility in case of breaches, including by ascribing the behaviors and effects of the employment of AI to one or more responsible natural persons. Having sought to draw certain linkages concerning expectations around intelligence in armed conflict and the associated legal framework, I will now propose 4 properties of legality and corresponding conditions of legality. If established, these properties and conditions would arguably entail significant consequences concerning what kinds and degrees of reliance natural persons may place on AI-related techniques and methods in relation to armed conflict. The first property of legality I propose concerns ascription of legal agency, in the sense of the capability to perform obligations incumbent on legal subjects, only to natural persons. I would pose the first property in the following terms. In relation to armed conflict, only a natural person acting individually or multiple natural persons acting in a group are capable of performing an obligation, whether it's on behalf of a state, international organization, or non-state party, or not on behalf of such an entity. Accordingly, in relation to armed conflict, an artificial or synthetic agent is not, and multiple such agents are not, capable of performing an obligation. The positive and negative corresponding conditions of legality might be formulated in the following terms. First, to satisfy a condition of legality, a use of an AI-related technique or method in armed conflict, including the behaviors and effects connected with that use, must be capable of being attributed to a natural person or to multiple natural persons acting in a group. Second, and conversely, in relation to armed conflict, it is impermissible for a natural person individually or multiple natural persons acting in a group to use AI if that use, including the behaviors and effects connected with that use, is not capable of being attributed to that person or those persons. The second property of legality that I would propose concerns the act or acts required of natural persons to perform obligations. I would pose this second property in the following terms. As a necessary element in performing an obligation in relation to armed conflict, a natural person acting individually or multiple natural persons acting in a group must undertake and carry out the necessary and sufficient act or acts required by the obligation, including by exercising cognitive agency. What conduct suffices to satisfy the required action concerning intelligence depends on the applicable rule, principle, and/or standard. The positive and negative corresponding conditions of legality might be formulated in the following terms. First, to satisfy a condition of legality in performing an obligation in relation to armed conflict, a natural person acting individually or multiple natural persons acting as a group must, among other things, exercise cognitive agency. Second, and conversely, in relation to armed conflict, failure by a natural person acting individually or multiple natural persons acting as a group to exercise the kind and degree of cognitive agency required by the obligation constitutes a breach. The third property of legality that I would propose concerns whether the legality of armed conflict-related conduct may or must be capable of being ascertained. I would pose this third property in the following terms. As a necessary element of legality, in relation to armed conflict, a natural person acting individually and multiple natural persons acting in a group may undertake and carry out only conduct, including the conduct that involves the use of AI, the legality of which is capable of being ascertained. The positive and negative corresponding conditions of legality might be formulated in the following terms. First, to satisfy a condition of legality in relation to armed conflict, a natural person acting individually or multiple natural persons acting in a group must ensure that the legality of any conduct that he, she, or they undertake and carry out, including conduct that involves the use of AI, is capable of being ascertained. Second, and conversely, in relation to armed conflict, it is impermissible for a natural person acting individually or multiple natural persons acting in a group to undertake and carry out conduct, including conduct that involves the use of AI, the legality of which cannot be ascertained. The fourth and final property of legality that I would propose today concerns whether responsibility must be capable of being applied in case of a breach. I would pose this fourth property in the following terms. As a necessary element of legality in relation to armed conflict, a natural person acting individually and multiple natural persons acting in a group may undertake and carry out only conduct, including conduct involving the use of AI, in respect of which responsibility is capable of being applied in case the conduct constitutes a breach. The positive and negative corresponding conditions of legality might be formulated in the following terms. First, to satisfy a criterion of legality in relation to armed conflict, a natural person acting individually and multiple natural persons acting in a group must ensure that in respect of the conduct that he, she, or they undertake and carry out, including conduct involving AI, responsibility is capable of being applied in case that conduct constitutes a breach. Second, and conversely, in relation to armed conflict, it is impermissible for a natural person acting individually or multiple natural persons acting in a group to undertake and carry out conduct, including conduct that involves AI, in respect of which responsibility is not capable of being applied in case that conduct constitutes a breach. I'll now conclude by setting out some implications from my analysis concerning respect for existing law and the possible development of new law in this area. Now, I realize that much of what I have said may sound exceedingly abstract and theoretical, and that it might appear to be only thinly linked, if linked at all, to concerns around specific uses of AI in contemporary and future wars, especially recent reports of purported AI-related technologies being used in ongoing armed conflicts in Europe and the Middle East. In the discussion that will follow my presentation, I would look forward to engaging on specific reported uses of AI and how my analysis might encompass them. Now, spanning out for a moment, we seem to be witnessing a moment of heightened public attention and debate on responsibility for war-related conduct. While it lays down important protections, international law applicable in armed conflict as it currently exists nonetheless also tolerates far more extensive harm, not only to fighters, but even in certain respects incidentally to civilians, civilian objects, and the natural environment than any other field of public international law. States and their armed forces regularly justify non-disclosure of their armed conflict-related conduct and their capabilities on the basis of military secrecy. Further, it is relatively rare for states to share their legal analyses of their own conduct or their legal analyses of others' conduct. The most that those of us in the public are often promised is that internal investigations are being conducted and accountability will be provided internally. In many armed conflicts, members of an adversary population are typically left with little practical recourse to holding the opposing side to account legally. Indeed, I'm not aware of any armed forces that have already committed to the last two properties of legality that I laid out. That is, the ones on ascertaining armed conflict-related conduct and the possibility of applying responsibility in case of violations. In several key respects, this normative and operational framework concerning armed conflict and the assumptions underlying it are radically different from the vast majority of contexts in which regulation of AI are being crafted. Use of AI in war thus invites us to consider not only what is new here, but also what has long been accepted, or at least tolerated, when it comes to a system of meaningful legal protection in war, and what we should demand of that system moving forward and how it differs from other contexts. I've sought to craft my analysis today in a way that, if applied to contemporary and future armed conflicts, would help us evaluate the roles and responsibility of natural persons with respect to exercises of intelligence in the existing legal framework, whether the law is being respected or not, and whether we can meaningfully refer to the system as a legal framework in the first place. To be certain, I've only outlined some initial aspects of an approach here, and much more work would be required to ascertain, for example, what kinds and degrees of cognitive agency must be exercised by natural persons as part of processes aimed at performing the array of obligations incumbent on parties to armed conflict, and what limits, in terms, for example, of geographical and temporal scope of operations, may flow from these requirements. From my perspective, formulating properties and conditions of legality could provide a method that diverse states and other stakeholders may be persuaded to use to help identify and respond to issues and concerns in this area. Yet at the same time, perhaps this approach might help stakeholders pinpoint and address what precisely is of greatest concern when it comes to increasing reliance on AI-related techniques and methods in armed conflict, including, but also beyond, the conduct of hostilities, and to do so in a way that's susceptible to meaningful multilateral engagement and legal regulation. I thank you for the time and look forward to the discussion.
Now, thank you, Dustin. We're going to move to the Q&A portion of today. So for those in the room, if you'd please raise your hand, and my colleague Robin has the microphone. For those online, please feel free to put any questions in the Zoom chat. And for both participants online and in person, please introduce yourselves before asking your question. So I see a hand up with Berenice. Do we have any other questions in the room? We can take a few. Berenice, you can go first.
Thank you very much, Dustin, for this very interesting presentation. I'm Bernice Boutin, researcher at the Asser Institute and head of the DILEMA project. So I would absolutely agree with you that cognitive agency is necessary to perform legal obligations. But what we know with AI system is that the very use or presence of AI system in the decision-making process will reduce the capacity to exercise this cognitive agency. So was not fully clear for me from your talk what would be the implications of the lack or limited exercise of cognitive agency. Does it mean that then the obligation is not performed, there is a breach, there is a responsibility, or does that actually lead to a responsibility gap? Because if the natural person cannot perform the obligation, it cannot breach the obligation either, and therefore some may argue, well, then there's just a responsibility gap. I'm wondering how you approach this.
Okay, any other questions? Yeah, at the back there.
Hi, thank you for the talk. It was very interesting. I'm Max Wester. I'm sorry to say I don't have any legal background. I'm just some schmuck off the street. I was wondering, based on your talk, would you say that you're essentially classifying AI not as something that can take legal responsibility for an action, but more as a tool that will have to be used? So that if somebody is following an order given by or informed by AI, they are then responsible rather than whoever has developed the AI in order to provide them the information to give that order?
Okay, if we have one more in the room, yeah, also at the back here, and then we'll turn over to you, Dustin.
Hi, thank you so much for the talk, Professor, and it was really interesting. One thing that I wanted to ask is about the nature or purpose of the use of the AI. So, for example, if the purpose of the attack or purpose of using the AI is to evaluate the percentage of survival of a military target compared to a civilian, do you think that that changes the legal framework that needs to be adapted to it? Sorry, to introduce myself as well. My name is Ahmed Al-Ammar. I'm from Leiden University, and we're here to learn more about this. Thank you so much.
Go ahead.
Thanks very much for the question. So, Dr. Boutin, my sense is that you and I might agree on the necessity to exercise cognitive agency to perform an obligation. I have not, though, got a sense that states agree on that yet. I think it would be helpful if states did agree that that was actually a component part of the performance of the obligation. I think that then raises the second question, to me it's a second order question that you raised, which is, does this then reduce, does the reliance on AI methods or techniques reduce the cognitive agency of the natural person or persons? And to me, it depends on the form of reliance and the nature of the method or technique that's being relied on, and whether it's one person or multiple people, et cetera. I don't think it actually necessarily reduces agency. I think it can actually enhance agency, potentially, if it provides greater information for certain contexts, for instance. Because I think the question for me is not, it might be a reduction, it might be an enhancement, and it might be a transformation, and I'm not sure. I would like to pose this question to the audience, like what the best way to think about it is. And then I think, so the way I'm trying to conceptualize is it's first and foremost would be a failure to perform the obligation. So it would be a breach of the existing primary rule that's incumbent on the subject, namely the state, because the natural persons acting on its behalf have not undertaken sufficient acts in the sense of part of the act being this exercise of cognitive agency. At the same time, it could result in what some people characterize as a responsibility gap, if by responsibility gap we mean that in case of breach, it's not possible to apply responsibility because there's no natural person capable of being against whom responsibility can be ascribed on behalf of the state. So it could operate in that direction, but I don't think it necessarily has to. So I would frame it primarily in terms of non-performance of the obligation. And we would need to look at each part obligation concerned, whether it relates to humanitarian services, deprivation of liberty, the conduct of hostilities, or other areas, to determine what precisely is entailed in this obligation to exercise cognitive agency, and the extent to which, if at all, AI-related methods may be used to perform that part of the obligation. So I think it might reduce, it might enhance, it might transform, but I'm not sure. Max, so I think part of the way I see it is that, so far as I can tell, states presume that it's only natural persons who can perform their obligations. And so they are not ascribing legal agency to other entities, such as an AI system. And I think this is a really important building block to understand the role of reliance on AI in armed conflicts, and whether or not something like artificial or synthetic legal agency should or should not be permitted. So far as I can tell right now, it's not. There's an assumption here that I'm making, though, and based on a relatively small amount of positions put forward by states. And I think then this view would be that the AI method or technique that's relied on could function only as a tool and only as an assistive tool in the performance of the cognitive agency, the exercise of cognitive agency, and could not displace that obligation or and otherwise reduce it such that it can be performed by the machine system or the constructed system itself. Ahmed, I think I understood your question partly, but just to, if I might ask you just to restate it to make sure that I captured it in full.
Yeah, sorry. So my question is mainly about whether the nature of the purpose of the use of the AI changes how you would approach the legal framework. So, for example, let's say its use in use ad bellum compared to use in bello, its use on maximizing survival chances of civilians, or maximizing military gain, like these different the natures of the usage.
Thanks. Okay. So in short, no. So the approach that I'm elaborating here is seeking to sort of get very much back to the basics. It might be so basic that everyone in the room already presumes that everyone agrees on it, which would be excellent from my perspective if that's actually the case. But it's not dependent on the nature or character of the obligation. What I'm trying to instead articulate is what we expect of natural persons in performing obligations on behalf of legal subjects, whether it's in the use ad bellum or use contra bellum context, whether it's in the human rights law context, whether it's in the IHL context, within IHL, whether it's on the process of conducting hostilities in military operations. I think that's part of it. It also, though, makes room for the fact that in contemporary armed conflict, the performance of legal obligations is almost always a team effort. It's very rarely a single person. And that's why I speak of multiple natural persons, acting in a group, that they can perform the obligation. But no, in short, it doesn't change based on the nature or purpose of the use. It, though, then requires us to consider, as I was mentioning to Dr. Boutin, what exactly each obligation concerned entails in terms of exercising cognitive agency, right? So if you're, for example, performing the obligations related to ensuring that any exercise of individual or collective self-defense in response to an armed attack satisfies obligations concerning necessity and proportionality, that would require a different type of cognitive exercise of agency, I would imagine, than, for instance, the exercise of cognitive agency entailed in performing obligations related to determining who may be subject to targeting and direct attack in the conduct of hostilities. There might be similarities in some ways, but these are different exercises of cognitive agency. They might both require developing sufficient situational awareness, et cetera, and ultimately performing certain evaluative decisions or judgments, but we'd want to go obligation by obligation to determine what that cognitive agency performance would be entailed within it.
Okay, we do have some questions online, so I'm going to read those to you now. So our first question online from Fawad Ureman, joining us from Pakistan, who has spent 20 years with the UN, NATO, and is currently working on Pakistani AI policy. Considering the implementation of IHL and the inherent inaccuracies and errors of AI algorithms, What are your thoughts on the development of an international AI law or convention specifically governing the use of AI in military operations? How might such a framework address the unique challenges posed by AI in ensuring compliance with humanitarian principles and accountability in warfare? Now, we also have another question here on AI policy and law from Jordan Franks, joining us from South Africa, currently completing an LLM at the University of Bologna. Would you say that it's better to pursue AI policy specifically dedicated to AI in armed conflict, something that perhaps mirrors the AI Act in the EU, but also dedicated specifically to military use? And a final question online from Harry Brown, joining us from the University of Leicester in the UK. What is your perspective of referring to lethal autonomous weapons as agents as opposed to tools in inflicting harm on combatants? What legal implications do you see from either perspective?
Great, thanks. So in terms of Frad's question around this, I think that was stated the inherent inaccuracy of the algorithms, et cetera. So the part of what I'm trying to puzzle through right now is how to take what requirements exist within the law and what we assume about who can perform the obligations and what they can and can't rely on in terms of performing those obligations. So if there is a source of information that is inherently unreliable, that would not be permissible to rely on, because you need to be able to rely on things that are reliable. So if there's an inherently problematic algorithm, I would say that that's not susceptible to reliance. But I don't necessarily think all data reliant and algorithmic frameworks are inherently unreliable. I think if they're subject to sufficient testing and validation and other considerations, they can actually enhance certain aspects of the cognitive function associated with performance of obligations. I think there's other considerations around being able to determine how you can ascribe the acts, in particular the behaviors and effects flowing from those employments, including the so-called algorithmic opacity and whatnot. But there's a first order question that I would pose before getting to the second order question, which is trying to figure out what the law already requires of natural persons in performing these different types of cognitive agency in connection with different AI-related techniques and methods, and how reliable, accurate, predictable, et cetera, that they might be. In terms of Jordan's question around whether it's better to pursue, whether it might be useful to pursue AI-specific regulation concerning armed conflict, I think there's various ways to approach the question. I personally do not have a view yet on whether or not it makes sense from a policy perspective to pursue a specific new instrument. I think part of my sense of whether that would be desirable or not depends on whether states and other concerned actors would agree to the premises underlying my argument here. If already it's assumed and agreed that all of the states potentially that may be parties to armed conflict would not engage in conduct that is not ascertainable, is not susceptible to legal scrutiny, that does not reflect an exercise of cognitive agency, I'm not sure that new law is necessarily required, but I think you would need a specification of the existing law in order to ensure that the aspects I'm raising are agreed. Because right now I don't have a firm sense that these are actually the agreed approach. I also think it could be useful to develop new law in this area, or at least to reaffirm the existing normative commitments underlying the law while taking into account what is potentially different about AI-related methods. But ideally, and very hopefully in a way that doesn't reduce already the limited scope of protections in armed conflict for the people, objects, and the natural environment affected by armed conflict. And I'm not certain if now is the moment from a multilateral perspective to pursue such an initiative or not. In particular, trying to learn lessons from the autonomous weapons multilateral debate, I'm not sure about that. And then in terms of whether lethal autonomous weapon systems, Harry's question around lethal autonomous weapon systems might best be considered, characterized as agents or tools. So I think from a legal perspective that the best way to approach them is as means of warfare or as weapons of warfare that are either prohibited, that they might be prohibited if they would fall under existing prohibitions. They might be employable, but only if the natural persons involved can perform the obligations incumbent on them. And so I don't think necessarily this question of if they, so I guess the first point is I don't know of a state that would say that a constructed system such as a lethal autonomous weapon system is capable itself of having any legal agency attached to it, that it always has to go back to a natural person. So then it would be a tool in the sense of something that would assist the natural persons in performing the obligation. That's my best understanding of the law as it exists right now and the assumptions underlying it.
Great. I think we have time for one final round of questions. So we're going to begin in the front here.
Thank you, and thank you, Dustin, for joining us here in person. Claudia Klanowska, PhD researcher at the Astor Institute. I was triggered by your use of the term intelligence. So my question goes to the distinction that you drew from the very beginning between artificial and natural intelligence. And I think that there's a lot to unpack here with this that I'm sure that you do more in the paper, but it seems to, on the one hand, assume already that these systems are intelligent, which is of course also a risk in itself, right? To reinforce these ideas about systems that sometimes can be very simple in performing, a certain order of rules. So that's kind of one question of are we not here falling into that reinforcement of showing statistical computation as intelligence? And then I think that links a little bit to the second part of this. If we divide and distinguish artificial intelligence from natural intelligence, we then also might forget about all the engineers and developers and other natural persons that are also involved in the making of these systems, right? So that separation then kind of can lead us to also then forget about maybe their responsibilities in the performance of all the obligations that you've mentioned. So that's where my question goes. Thank you so much.
Great. The next question here, Terry.
Hi, Dustin, thanks a lot for that really thought-provoking talk. It's great to have you here and see you again after quite a long time. I have... oh, yeah, that's right. I'm Terry Gill, Emeritus Professor of Military Law at the University of Amsterdam in the Netherlands Defense Academy. The question I have and a kind of suggestion is the following. I'll begin with a suggestion, if I may. It sounded to me that I agree with you that there's an impasse right now with the whole debate around autonomous weapons and the committees at the UN and so forth, and it's kind of run into a dead end. Not that this is the be-all and end-all, but one way you might consider getting around that is to do kind of a Talon manual type thing, where you get a group of people together, both from the military, from scientific background, from diplomacy, and try to put together some guidelines. In other words, flesh out some of the things that you've said today. That could be helpful for states to formulate their policy. On the basis of the Talon example, I know that it isn't the manual itself, it was the process it started that really has borne fruit, I would say, through stimulating states to formulate policy where they otherwise probably wouldn't have or would have been still kind of reaching for where they wanted to go with it. So it could be a helpful tool, something to think about. A lot of bright people here in the room that would probably be interested in participating in a project like that. My question is, and this may sound, I don't know, obtuse or something, but I kind of get it, and I don't get what the problem is with this whole question of. Obviously, to me, it just seems like it's staring you in the face. There's always a human being involved in some way, shape, or form in decision to deploy a particular type of AI system in a particular context. And holding a machine responsible sounds to me like we're going back to the medieval period when we put donkeys on trial for kicking people. If a guard dog attacks a person and injures the person severely, we don't put the dog on trial, we put the owner on trial for putting the person in a position where the dog could injure them. So to me, that's kind of a non-discussion. What I really do think you need to do, though, is to kind of put the nail on in the particular type of application where the decision is actually being made. And so to come to your point that you said, is it transforming, is it expanding or diminishing? I'll tentatively put my own answer to that. I think it transforms. I think it depends, as you said, on the particular application and normative framework, where in that the cognitive agency takes place, and how it affects the actual performance of the obligation. But there's always a traceable person, whether it's the commander in the field, the higher agency that has allowed the weapon to be deployed in the first place, the decision at the strategic level to use a particular system in a particular context. So there always will be human agency there in some way, shape, or form. So there always will be responsibility if an obligation isn't met. Because international responsibility, I'm not talking about criminal responsibility, is objective. It's objective fault liability. So as soon as an obligation is breached, there's automatically, unless there's a, as you pointed correctly out, a circumstance precluding wrongfulness, ipso facto there's responsibility. And it doesn't make any difference exactly where in the circle that happened. It'll all be traceable back to a state. And it's obviously agents of the state at some level that made the decision, so that whether it's Tom, Dick, or Harry who actually did it isn't really that important in terms of attaching responsibility to the state for its breach of an international obligation. So I don't know, maybe I'm oversimplifying, but that's what it seems to me anyway. So if I'm wrong on, if I didn't get it, tell me what I got wrong, okay?
A final question? Yeah, you're.
Yeah, thank you. Jeroen van der Boogaard. I work as a legal counsel for the Ministry of Foreign Affairs, of the Netherlands. We hold we are the chairman of the GGE laws that, according to Professor Gill, is a dead end. So that's where I work, on dead ends. Dustin, thank you very much for your talk. It's very interesting. I'm trying to translate your analysis to what I see in the GGE laws and how we think about autonomous weapons nationally, and also about military use of AI. So I was wondering, because there's this your point on the exercise of cognitive agency. I wondered how that relates to the argument that is made by some states in the GGE laws, more specifically the US, that the concept of control is not part of the existing legal framework of IHL, that is mostly. So I wonder whether you can reflect on that a little bit. And also, I think I'll save some questions for the drinks, but just for now, also in your analysis, I was wondering how the existing international legal sources, on which one you would rely, and on which you would base your analysis in this, because it's, as you said, and I find it fascinating, but I'm not intelligent enough for this theoretic framework in this sense, so I was wondering how you relate that back to international law. Thank you.
Go ahead.
Great. Thanks very much. So, Claudia, so I firmly agree with you that we ought not to lose sight of the multitude of natural persons involved in the performance of the obligations. And I do think it's useful to distinguish between natural and artificial intelligence, and in doing so, not to I can never say this word correctly, anthropomorphize the artificial intelligence. So from my sense is that I'm hopeful that if we take into account all of the people as this sort of team effort approach to compliance with IHL, including the engineers, the data scientists, the others who would be involved across the life cycle or the life and death cycle, depending on who you ask to frame this, of this reliance, that it doesn't focus only on the one person, for example, just the commander. It would actually have us look into how each person involved in performing the obligation, whatever that specific obligation is, has exercised cognitive agency in connection with the performance. So for instance, if as part of the so-called targeting cycle, a AI-related method is utilized to identify or nominate targets, we'd want to look at each of the people involved in the formulation of the concept of operations, in terms of the structuring of the algorithmic framework, in terms of deciding which data will or will not be utilized, in terms of making the evaluation as to how to convert the data into information that's subject to legal judgment, and which is, I would hope then, a way that we can center the role of the natural persons while not also anthropomorphizing the artificial intelligence, and instead seeing that for what it is, which is a way to either enhance or detract or transform the way that those natural persons are jointly performing the obligation. So I would frame it as in terms of a joint performance of the obligation rather than individual single person performing that obligation. And I completely agree that we ought not to anthropomorphize these and talk about intelligence systems, intelligence machines, intelligent otherwise. Instead, it's this notion of artificial intelligence in terms of developing computationally based understandings of intelligent behavior and then embodying those in data algorithms, et cetera. But it's always then the extent to which a natural persons may or may not rely on those computationally based notions of intelligent behavior. So I think we're in pretty good agreement. Professor Guild, so nice to have you here. For those who don't know, he was one of my 2 LLM thesis advisors, so it's always nice to have fresh views and also ongoing critique of the ideas. I'm very much a fan of the Dutch model in many respects, including these. Well noted on the Talon manual. My understanding is they've been discussing since 2016 the potential for a manual on autonomous weapons, and there's been no uptake. I think this is a way to develop it, and I think there's a diversity of views on the extent to which that would or would not further bifurcate the normative framework, or might actually invite states that otherwise don't have views already to set them out in some ways. So it's an interesting idea, among others, to develop the different views, and especially to encourage states to elaborate their views on these issues, which, from my perspective, is the most important element of all of this, as you said. Yeah. And then, so I'm chuffed to hear that your sense is that there will always be a traceable person for this. I have rarely been able to have that instantiated in writing from legal advisors from governments or militaries in a way that would say, they say more or less, we would never employ a system that would not bring about the behaviors and effects that we want, but we will not commit to making sure that all of those behaviors and effects are traceable from a legal perspective in terms of applying legal responsibility to one or more people necessarily. That might be an assumption underlying the system, and if it is, I would like to make that explicit. I think there could be value in making that explicit. And I would be very happy if that were the case, because I think that is an element of the legal framework, is that that's possible to do. I do think, though, in terms of what I would never begin to assume you might be missing something or oversimplifying something, but I do, part of what's been reported in certain contexts now is the reliance on whether we call it AI or something else, because I think there's also terminological inflation sometimes where everything becomes AI, but it's not actually AI. But if we talk about algorithmic frameworks and data-reliant systems, some parties today in armed conflict are reportedly reducing temporally the window for certain big life and death decisions within systems of reliance where multiple people are involved, in ways that are only partially known to the public. So I can't make a legal evaluation of whether or not those systems necessarily comport with the performance of the obligation in full, and whether or not the 30 seconds or 3 minutes or 30 minutes itself on its own allows for the obligation to be performed in terms of exercising cognitive agency and all the assumptions that go into the different interreliances that occur in terms of formulating the algorithmic frameworks, the data, the ingest of it, the timing, somebody exercising a type of cognitive agency. But I would submit that if we think about these things in terms of whether or not that person or that group of people are exercising sufficient cognitive agency, I think that might help us identify what exactly the obligation requires and whether or not, in specific instances, that obligation can and is being performed based on all of those inputs. So I think there's real concerns by some people, but it's all based on partial information. For example, whether or not that 30-second gap and you're just more or less an automation bias saying, yes, already the machine's nominating this, I will do this. Whether that's an sufficient exercise of cognitive agency is an open question, I would say, right now. It might be, but I would need to know more, I would say. In particular with respect to the provision.
That ends up in being an omission then? Let's say that the 30 seconds isn't enough
Right.
to make an informed proportionality assessment,
Right,
for example.
totally.
And the attack ends up causing excessive civilian harm.
Right. Yeah.
Obligation hasn't been met, right?
So
responsibility follows.
So,
Simple as that.
I detect so much agreement in your and my views on this, and I have yet, though, to see that instantiated by governments in their views at the international level. Yeah. Jeroen, thanks very much for your comments. I think the notion of exercise of cognitive agency is not synonymous with the concept of control that's been set out in the autonomous weapons debate. My understanding of the US view is that it says there's no overarching or underlying, so either over or under, notion of control inherent within IHL as such, and said you need to look at each different principle or rule to determine what is required, but the notion of control itself is not an overarching term that you can say is necessary. I think you might get to a very similar place, though, in terms of what would be incumbent on the natural persons responsible for performing obligations, whether you say control or exercising cognitive agency. I prefer exercising cognitive agency because I think sometimes control is assumed to mean that you can control all of the effects, and I don't think that the existing legal framework requires control of all of the effects. I do think the existing framework requires that one or more natural persons exercise sufficient cognitive agency in connection with, for example, in cognitive hostilities directing attacks, determining whether a person or object is susceptible to targeting, direct attack, proportionality, precautions, etc. But control to me it might be just similarly to a similar place, but it's of a different nature, I would say, than this underlying element of the properties of the performance of the obligation. And then in terms of the sources, so I think I would look, for the content of the obligations relative to exercising cognitive agency. I'd need to look at each obligation in turn. So with respect to the obligation for distinction in targeting, look at the relevant treaty provisions, customary rules, and say what exactly is required. So for instance, you would need, I would assume, but I haven't looked at this fully, to say you need sufficient situational awareness of the context. You need to be able to sufficiently determine whether or not a person is or is not subject to targeting and attack. So if they're civilian directly participating in hostilities, member of an organized armed group, member of state armed forces. Then the next level, going to proportionality, saying if there is potential for civilian harm, then this is the proportionality assessment, and then making an evaluative decision or a value judgment about that. And that exercise of each one of those three parts is what I would consider to be part of this exercising cognitive agency, right? It's not necessary, the other terms you could use are exercising cognitive capability, exercising a mental agency. I like cognitive because it gets at the notion of intelligence, and it also doesn't mean, I think you could also frame it in terms of moral agency, but I think then that gets quite difficult to distinguish between moral and legal obligations. So I think there's something to be said for cognitive agency more than the other, but I'm very open to critiques on that. And then the last point on the sources, in terms of those last 2 points, which I understand are quite maybe ambitious for the properties of legality, for ascertaining armed conflict-related conduct, and for imposing responsibility in case of violations, especially in an environment where I don't know of an armed forces that like to say what they've done, let alone to tell you all of the things they've done to imply responsibility. They might be doing that internally, they might not be. And I think for especially the non-deterministic systems, some of the machine learning, it is actually harder. It's of a different nature to try to ascertain the conduct and the causality from the inputs to outputs and who can and can't be responsible and what it's to know those. I think that's a little different than some of the deterministic systems. Last point, for the questions around the legal source for being able to ascertain conduct and impose responsibility, I look to the obligations in the Geneva Convention, the additional protocols related to obligations to investigate or investigate and prosecute or extradite for breaches. So I think at a conceptual level, it's difficult to understand how a state could perform that obligation if it doesn't have in place the sort of forensic capability internally and potentially externally too, in relation to external actors, to be able to determine whether or not the alleged breach by anyone, irrespective of nationality, has been conducted. So for example, in a conflict far away, if an alleged perpetrator is in your jurisdiction, to perform the obligation, you'd need to be able to ascertain whether or not that conduct was or was not capable, did or did not comply with the law, and you would need the technical means, in a sense, to be able to do that, to discharge the obligation, or else you're just extraditing all the time, right? So I think that's one of the sources I would find for part of those last two properties of legality.
Okay, we're out of time, so I'm sorry that we can't get to all of the questions, but thank you for the very interesting questions that were asked and the insightful responses. If you are interested in military AI and international law, I invite you to follow along with work of both the Harvard Program of International Law and Armed Conflict, as well as the DILEMA project on designing international law and ethics into military AI here at the Asser Institute. In particular, you can stay up to date with DILEMA project activities and research at asser.nl/dilemma. And also in the lobby, you can find some publications with QR codes where you can find some of the team's research. So I'd like to invite everybody for a last time to thank Dustin for the lecture today.